Good afternoon, good morning, everybody. Let me just see. My first test is let me just see if I can share my screen with you. I've got a few slides here just to illustrate what I'm saying. Just one second. There we are. That seems to have worked okay. Perfect. Right. So look, the B word. Apologies if you've logged in today to hear me drink beer or listen to me drink beer, talk about basketball or baseball. I'm afraid it is very much about Brexit today. Brexit, intellectual property, and data privacy. So we've got about 6 weeks to go until the UK sort of Brexits properly. And I think it's fair to say that two of the most impacted areas will be intellectual property and data privacy. So the purpose of today is to look at some of the main changes, see what they mean in practice, and hopefully give you some tips, maybe even some top tips about what you and your clients should be doing in the run up and shortly after Brexit. So where are we? It's been going on for a while. So I just checked today, and our referendum on leaving the EU was back in June 2016. So this is our 5th year of talking about Brexit. But the sort of the most recent events are the UK actually left the EU 31st of January 2020. So that was our sort of official Brexit date. But then we went into this sort of what I would describe as a transition period from the 1st of February. The UK government always refer to that as the implementation period, so or IP. And rather ominously for those of us that are IP lawyers, they talk about the end of the transition period, the end of the implementation period as being IP completion day. So IP completion day is 11 p.m. on the 31st of December 2020. So I suppose the question for today is what happens then? Well, listen, I'm afraid to say there's still a little bit of uncertainty. The UK and the EU are still negotiating some sort of deal. So there's still some talks going on. I think what I'd say that given that we are only sort of 6 weeks away from that IP completion day, I would suggest that not very much is going to change. And if there is a deal, it's likely to be a sort of fairly light deal. But I'll try and flag as we go through the areas where I'm aware there are talks going on. So it's really just a question of keeping an eye out and see what happens, in those particular areas. But by and large, I'd say 90 to 95% of what I'm going to say is going to be the deal. Is going to happen, regardless of what the UK and the EU may or may not agree. So in terms of what happens at IP completion day, essentially looking back, the UK has been in the EU for 40 odd years. An awful lot of law has come out of the EU in that time. It's basically come out in two forms. Either it's come out as a directive, an EU directive, and with EU directives, the UK has actually had to implement that law into its own national law. So as far as that law is concerned, that's kind of with us to stay. We've already sort of baked it into our national law, and that doesn't change. The other source of law for us would be EU regulations. So that is law that goes directly into our national law without us having to do anything. So technically, once we leave the EU, that law which is brought in by EU regulation falls away. But what the UK has done is essentially it's legislated, so all or nearly all of that law just gets carried over into UK law, and there's a series of legislation just moving that law from EU regulation into our national law. So basic point is that at 11 p.m. on the 31st of December, the law in the UK will be the same as it was at 10:59 p.m. on the 31st of December. So that's a reasonable start. After that, of course, it may well diverge. It will be for the UK to sort of make its own laws after that. and we may find it diverges more in some areas than others. So, oh, that's the wrong way, sorry. This is not a picture of me in my office trying to work out what the hell's going on with Brexit. It's supposed to be a picture of a worried client, and I think the serious point is that clients, businesses are worried. There's a huge amount of uncertainty around, and they're looking to people like us to tell them what to do and to tell them what the law is going to be. So what I'm going to try and do is give you a little bit of certainty as far as I can in relation to both IP and data privacy, and give you a sort of little thumbnail sketch of what's going on in both of those two areas. So we get into the law. So a lot of businesses will have trademarks, and essentially at the moment there are two ways to get a trademark in the UK. Either you get a UK national trademark, or you have a EU trademark, which is one trademark which at the moment covers all 28 EU member states, including the UK. So same result, but two ways to get there. Now, post IP completion day, what I was going to say was that the UK trademark, the UK national trademark, will remain exactly the same. And that is largely the case, except we had a bit of news yesterday that there's actually going to be quite a big change at the UK IPO. And what they've now said is that almost certainly from the 1st of January 2021, the UK is going to require an address for service actually within the UK for any sort of newly filed UK marks. So currently you can have an address for service anywhere you like. From the 1st of January 2021, you've got to have a UK address for service. And I think that's a change which has been brought on by other changes, which in turn have been caused by Brexit. So UK trademarks, very much business as usual, but do note that sort of address for service change. As far as EU trademarks are concerned, I suppose the easy thing is, after the 31st of December, the UK will no longer be part of the EU, and therefore, if you want a UK trademark after the 31st of December, there's really only one way to get it, which is to file directly into the UK or go through the international system. But you're looking at getting just a UK trademark, and if you apply for an EU trademark, that won't include an EU trademark. So that won't include the UK. So that's fairly straightforward. That's nice and easy. Insofar as you have, or your clients have, existing EU trademarks, the situation is this: as at the 31st December, that existing EU trademark will be cloned. Will be automatically cloned, and essentially you will be given a brand new UK trademark. It will have the same filing date, the same priority date as your EU trademark, and that process is purely automatic. There's no fee payable, there's no examination, and you don't even get a certificate. So it's a purely automated process, and I think when you consider that there are just shy of 1.5 million EU trademarks, all of which need to be converted into UK marks as at IP completion day. You can see the reason why they're doing that. They're making that as automated as they possibly can. To put that into some perspective, in the UK IPO's busiest year, they dealt with, which was 2019, they dealt with just over 100,000 new UK filings. So that's an awful lot of. If you think 1.5 million new UK trademarks, that's an awful lot of trademarks for the UK IPO to deal with. So in practical terms, you go to bed on the 31st December with an EU trademark covering 28 member states. You wake up the next day and you've got an EU trademark covering 27 member states, and you've got a brand new UK trademark as well. So that's the deal with existing trademarks. I think that's reasonably straightforward, reasonably clear. Insofar, one thing I should say is that although that's an automatic process, it is going to be possible to opt out of having that new UK trademark. That's something you can only do after the 1st of January. We haven't seen the forms for doing that yet. And we were kind of just thinking about this in the office the other day about why you might want to opt out of having that new UK trademark. And the only real reason we can see is if you've done some sort of agreement with a competitor, entered into some sort of coexistence agreement under which you have agreed not to have a UK trademark. And in fact, I've got one or two of those amongst my clients. There may be circumstances in which you are looking to give up that cloned right, but I would suggest that's going to be reasonably few and far between. If you haven't, if you've applied for an EU trademark but it hasn't quite been granted as an IP completion day, 31st of December, maybe it's still going through the system, or maybe it's been held up by an office action or by an opposition. You don't get a cloned right in the UK, but what you get is the right to reapply in the UK, and you get a period of 9 months to reapply for that same right in the UK. If you take advantage of that, you get to keep your filing date, your priority date for your existing EU application, but essentially you start again in the UK. There's a fee payable which will be the same as applying for a brand new UK mark, and it goes through examination in the same way as it would do if you're applying for a UK mark. So that's that. So if we just move on to designs, pretty registered community designs, RCDs, pretty similar to trademarks insofar as you've got a published RCD as at the 31st December. You get that cloned, and you get a free UK registered design with the same filing date. Very much the same deal as for trademarks, so no fee, no examination, and I think much for the same reasons. There's about 700,000 registered community designs at the moment, so again a lot of work for the UK IPO to do to move those across. In terms of unregistered community designs, obviously the UK will drop out of the unregistered community design system as at the 31st of December. But what the UK will do is they will essentially clone the rights that you have as at the 31st of December. And what you will get is what we're calling a continuing unregistered design, or CUD, which will protect you in the UK for the rest of the term of your unregistered community design. So you won't lose out there. You will just get the same right mirrored or cloned into the UK. So that's quite straightforward. What I think is more difficult is that after the 31st of December, because the UK won't be part of the unregistered community design system, you won't be able to get an unregistered community design. The UK is going to create this brand new right, which is called a supplementary unregistered design, which will mirror the unregistered community design. And how that will work is it will basically give you the same rights in the UK as you would have had in the EU. Now, the slight sort of trap or the slight trick there is that whether or not you qualify for that SUD, that supplementary unregistered design, will depend on where you first disclose your design. So if you first disclose it in the UK, you're going to qualify for the UK's version, the SUD. If you first disclose it in the EU, you're going to qualify for the traditional EU right. So there's a real choice for businesses to make there about where they actually disclose their right. Now, if you bear in mind that the unregistered community design system it's pretty flexible, so it protects 3D and 2D rights, and it's been popular with industries such as the fashion industry, where designs tend to be they don't tend to hang around for very long, and it's a design that it's a right that only lasts for 3 years. So if you're in that sort of fashion industry and you're relying a lot on unregistered community designs, you've really got to make a choice about what's best for you. Do you want the unregistered UK right, or do you want the unregistered EU right? So I think the real sort of choice you've got to make is, do you attend an exhibition in the UK and disclose your design there for the first time, or do you sort of hold off on that and disclose in the EU first? So there's some real commercial decisions to be made there, which I think clients have got to be very careful not to sleepwalk into, and make sure they know what they're doing. And just to sort of finish it off on designs, the other sort of design right in town, if you like, is the UK's design right, which we've had for a number of years. It's a bit different to the EU design in that it only protects functional designs. Previously, it was available for EU residents and EU businesses, but post 31st December, it will only be available for UK residents and UK businesses. So that's a right that will no longer be available to people in the EU. Little bit easier, patents and copyright, and I think I'd probably put trade secrets in this basket as well. So patents, mostly unaffected actually by Brexit. The European Patent Convention is an international convention, nothing at all to do with the EU. So the UK leaving the EU doesn't affect it in any way. So you can still continue to apply for your EU patents and designate the UK as a country within that European Patent Convention, and very much the same for the European Patent Office, which is not an EU creature. It's just a creature which exists because of international convention. So patents, I suppose, as we were really, not a lot of change there. Copyright, pretty much the same. A lot of copyright is sort of harmonised by international treaties such as the Berne Convention and the ICC, and those continue to apply. So you're still going to get reciprocal protection for copyright. So if I have copyright in the UK, I'm still going to get reciprocal protection in the EU and in the US and largely worldwide. So no change there. Some of what I would describe as sort of allied right, so the sort of what's always referred to as the sui generis database right. That's an EU right, so it will no longer be available in the UK. But again, the UK will be creating a kind of their own version of the sui generis database right. So that is a change, but it's very much those sort of allied rights, those EU creatures, which will change. And as I said, very much the same for trade secrets. Not a lot of change on that side. There was an EU directive on trade secrets, which the UK has implemented, but I don't think it made a huge, if any, change to our national law. So it's pretty much as you were there. The only thing I would say about copyright is that a lot of the sort of the harmonised law on copyright has grown up through case law, particularly case law of the CJEU, which as of day one, sort of the IP completion day, the UK will sort of take over, and it will be the same. What slightly remains to be seen is to what extent the UK will diverge or drift away from the sort of central EU position. And I think it must be right that there will be some divergence over time. as the UK courts start to sort of look at these copyright issues, and they may come to different conclusions from the EU court. So there will be some divergence in the sort of approach and interpretation over time when it comes to copyright. And this is where it gets, to my mind, actually sort of slightly perplexing, and it's this whole area of parallel imports, which I personally find the sort of, on the IP front, probably the most difficult area to get my head round. So current position is we have this sort of EU and indeed sort of UK-wide exhaustion of rights. So what that means in practice is if you are, let's say you're a licensed distributor and you have the right to put a product onto the market in, let's say, the UK, that product can then be moved around and put on the market in every single EEA member state. So once it's been put on the market anywhere in the UK or the EU or the EEA, the rights in it are exhausted, and it can be sold anywhere you like in the EU. So that's the current situation. Now, from the 1st of January 2021, we get this kind of asymmetric position, which, as I say, is slightly odd to me. And the position is really this, is that insofar as you are exporting products from the UK to the EEA, no exhaustion applies. I'll try and explain that with an example in a second. But insofar as you are going the other way, insofar as you are importing products from the EEA to the UK, the exhaustion rules apply in full, and you do get exhaustion. So if we take the example of someone who is authorised to sell products in the UK, as of the 1st of January, they put their products on the market in the UK, but that's it. They can't move them anywhere else in the EU, the rights aren't exhausted, and they would need a separate permission to then resell those products into the EU. But if a company or a business is authorised to put that product on the market in, let's say, Germany or France or anywhere else in the EEA, that product can then be moved around both within the EEA and in the UK. So the rights are exhausted where you are marketing for the first time in the EEA. So as I say, I find that a slightly odd position, but that's where we are at the moment, and that is definitely the position as from the 1st of January. I think the UK recognise that as a strange position, and there is going to be a consultation on that in the new year, and I know the UK are going to look at changing the position. I have to say, I really don't know what they will change it to. There's some thought that we may just get a sort of partial exhaustion. Maybe goods in some sectors would be exhausted, but all of that is really up for discussion. So it's one of those where it's going to watch this space, perhaps sort of second or third quarter of next year. We might start getting a few ideas as to where that's going to go. But for the time being, we certainly have this slightly odd asymmetric position. Top tips, so sort of drawing all that lot together, really. As far as registered trademarks and registered designs are concerned, getting your cloned rights in the UK is all about making sure that your original EU right is renewed. So if you don't renew your EU right, so if your EU right lapses because you haven't renewed it as at the 31st of December, you're not going to get your cloned right. So you do need to keep an eye on that EU right and make sure it's in force as at the 31st of December. Otherwise, that sort of cloning process I talked about won't take place. I think it's also important to actually know what you have and track what you have. So bear in mind, if you had a portfolio of 100 EU marks as at the 31st December, on the 1st of January 2021, you'll have 100 EU marks and 100 UK marks. And those 100 UK marks will have a separate existence to the EU marks. They won't be linked in any way. So you've got to renew them, look after them separately. But they are genuinely sort of independent property rights, which need to be looked after in the same way as any other property right. It follows from that is if you've got licenses or perhaps charges, security interests that need to be registered, you need to work out whether you need to register those licenses or security interests against your new UK right. So a bit of work to be done there. I think a big issue going forward is going to be this whole issue of sort of use and non-use. So remember that the current UK and EU position is that if you don't use your UK or EU mark for 5 years, then it becomes vulnerable to cancellation. So someone can come in and apply to cancel your UK or EU mark. And that will be and the position will be the same post IP completion day, except there will suddenly be lots of EU businesses who have acquired UK marks, and equally there will be UK businesses who've suddenly got a separate UK mark and an EU mark which doesn't include the UK. So I think what we're going to find is we've got UK businesses who are using in the UK but are not necessarily using in the EU, and vice versa. We're going to have French or German businesses that have got plenty of use in the EU but not any use in the UK. So you're going to find, I think, in 5 years' time that a lot of those marks are going to be vulnerable to cancellation, which as a business you might think's fine. You may take a view that you're not trading in the UK or you're not trading in the EU, so that's something you can live with. You can take that on the chin if and when it arises. But if those rights are valuable to you, you may just want to think about the way that your business is operating. Maybe you want to appoint a licensee or a distributor, and just make sure that you can hang on to those rights if they're valuable to you. And as I say, I think it follows that there's going to be a lot of cancellation proceedings. A lot of those may well be brought before the 5-year mark, just sort of test the water, because you may find that EU businesses who've suddenly ended up with a cloned UK mark don't really want it, and although they're probably not going to give it up, they're not going to disclaim it. They may not be prepared to defend cancellation proceedings. So we may well find there's sort of a proliferation of cancellation proceedings as a kind of way of clearing the market a little bit. But it does remain to be seen how that plays out. Obviously, you need to think about future applications. Can't say it too many times. The UK will not be part of the EU after the 1st of January. So if you want a registration after the 1st of January in the UK, you need to apply for it separately. So that may be obvious, but you need to keep your eye on that. Registered designs, I mean, they have the beauty of not having very much of any examination. So the chances are, if you want an EU registered design now and you want it to be cloned into the UK, you've probably still got time to apply for it and get it onto the register in the EU in time for it to be cloned on the 31st December. You'd certainly save yourself a little bit of money if you did it that way, rather than waiting until much closer to the 31st December, at which time you may not get it through in time. Just bear in mind, though, that both the UK IPO and the EU are likely to get very busy between now and the end of the year. So you do need to be bringing forward the times on which you might do those things. So I'd have thought don't leave it very much longer if that's a possibility for you. As I've said, clients need to keep an eye on where they are disclosing their designs, because that's going to dictate where they get that I'm registered right. Do they want it in the UK? Is that commercially important to them, or would they prefer to have it in the EU? Is that more valuable to them? Keep an eye on that. And then the whole sort of parallel importing permissions piece. Your clients need to work out what permissions they have to market these third-party goods, because the position is not going to be as simple as it was. It's not going to be enough that you just had permission to put it on the market in the UK, and that gives you, as in the old days, that gave you the right to market in France or Germany. You've actually got to have a look and see what permissions you've got, whether that gives you the right to market in Germany and France or in other places in the EU, or indeed whether you need to go and ask for those extra permissions. So hopefully that's useful in terms of sort of whistle stop tour of IP and a few top tips at the end there. I don't know whether there's any questions on that side of it, because I was going to now move on to data privacy, but it might be more convenient to take a few questions now if there are any.
Yeah, so we had a couple questions in the chat. The first one is if you could just repeat how the EU laws in general will be applicable from December 31 in the UK, that would be helpful.
Yeah, no, of course. So, I mean, by and large, there are, as I say, there's two ways that EU laws traditionally find their way into the laws of the UK. Either the EU issues a directive, which the UK, like every other EU country, takes and turns into its own national law. There's always a slight drawback about it because every country puts their own slight spin on it, but essentially every country takes that directive and implements it into their own law. So as far as that is concerned, nothing needs to be done because those laws have already been implemented into the UK and they already sort of sit there and they're not going anywhere as of the 31st December. The other possibility is that the EU has passed what we refer to as regulations, and those regulations have direct effect into the laws of the UK. So nothing for the UK government to do. Those laws just get put into UK law automatically. Now, as far as they're concerned, if the UK had done nothing, I think those regulations would no longer apply to the UK as of the 31st December. But in fact, what the UK has done, and there's a whole sort of scree of legislation, essentially it's picked up all of those regulations and it's put them directly into UK law, largely through a whole series of statutory instruments. So the end result is that by and large, the national law of the UK, which includes all of that EU law, will be as it was. So the law won't change from the 31st December to the 1st of January. It's kind of as you were. Everything has been moved across, which I think is probably oversimplifying it hugely, but that's the general gist of it.
Gist of it. Thank you. Another question is, what should ally members do if they have clients that they know operate or sell into the UK?
I suppose it depends what they're selling. So if they are selling their own goods, less of a problem, but they need to look at their registered design and trademark protection just to work out what they've got, insofar as they've got EU rights. Check to see that they will have been cloned, and keep those under management. I think the real trap is where they are using a distributor or a licensee to sell into the UK. and they've got to look at what they're asking what they're giving that distributor permission to do. Because pre the 31st December, that distributor would be able to circulate those goods around the EU. There may even be an opportunity here for clients outside of the EU maybe to appoint another distributor in the EU. So you've got to look at what permissions you're giving for that UK distributor or UK licensee, basically.
Great, thank you. I think that's it for the IP portion. If you wanted to move on to data privacy.
Yeah, sure, no problem. So data privacy. We all got very excited a couple of years ago, probably 2 or 3 years ago now, about the GDPR, which the General Data Protection Regulation, which remains a sort of the main word on data privacy in the EU. So I suppose the first question is does the fact that the UK is leaving the EU, does that spell the end of the GDPR for the UK and for UK businesses? Well, depending on which way you look at it, fortunately or unfortunately not. What the GDPR is one of those regulations which the UK has essentially taken steps to reproduce in its own law. So we have the Data Protection Act 2018, and what that does is it basically mirrors into UK law the EU GDPR. So it changes some of the terms, it changes EU for UK in a few places, but it is 99% the same. So we end up with a UK GDPR which applies to UK businesses, and it applies to, and we left with an EU GDPR which applies to to EU businesses. I suppose the slight complication for UK businesses is that insofar as they are dealing with data for people who are resident in the UK, they need to apply the UK GDPR. But insofar as they are dealing with data for people who are resident in the EU, they will need to apply the EU GDPR, which on day one, not a huge problem because both pieces of law are almost exactly the same, but there may be a slightly bigger problem as we move along and potentially as the UK's law perhaps diverges slightly from what there is in the EU. Having said that, there are some fairly good reasons, which I will touch on in a second, why the UK's data privacy law probably needs to stay the same or at least very close to what there is in the EU. So I wouldn't expect much change for some time to go, for some time to come. In terms of practical problems that this throws up, there's a number. One practical problem is that one of the benefits of the sort of whole EU system, the benefits of the GDPR, is that if you're a business with offices around the EU, including in the UK, you could take advantage of this sort of one-stop shop idea. So rather than having to deal with a data protection office in every single EU member state, essentially you nominate your lead office and you just deal through that lead office. You haven't got to deal separately with the UK ICO, the French equivalent, the German equivalent, etc. Unfortunately, with the UK leaving the EU, that falls away. So you will at the very least have to deal with the UK ICO and then one other EU equivalent, which is going to have ramifications for things like dealing with breaches. You're going to have to deal with the UK ICO in relation to UK data subjects, and you're going to have to deal with at least one EU data protection authority in relation to EU data subjects. That just makes things a bit less convenient, to be honest with you. The other two sort of practical effects, which I'm going to talk about in a bit more detail, are data flows and representatives. And for me, perhaps the most serious, the most sort of substantial impact here is this whole area of data flows. So, I mean, the basic position has been the basic position to pre-GDPR for a number of years, is that the basic rule is that you can't transfer personal data outside of the EEA unless you're transferring to a country which the EU has decided affords an adequate level of protection. And at the moment, there are 12 countries which are in that category. I won't list them, but it's countries like Japan, Canada, Argentina, Israel, New Zealand, Switzerland. But only 12 countries. And if you don't have one of those adequacy decisions, then you are what's described as a third country. So third countries would include the US, Australia, China, Russia. And they're all third countries. They don't have the benefit of one of these adequacy decisions from the EU. So on the face of it, you can't move your personal data from the EEA out to one of these third countries. So the question is, what happens to the UK once it falls out of the EU? So at the moment, you can move your data into the UK from the EEA because it's essentially part of the EU still until the end of the year. And that's a two-way street as well, because remember, the UK's got its own GDPR, or will have its own GDPR. It needs to decide what you can do with data moving out of the UK. So it kind of goes both ways. Now, what the UK has said is that it is going to treat both the EEA and the 12 countries that the EU has found to be adequate as having an adequate level of protection. So the practical effect of that is that if you're sitting in the UK and you want to move data into the EEA, or indeed into one of those 12 countries, no problem at all. You can do so because the UK has said that those countries give you an adequate level of protection. However, and this is the really big point, is that the same doesn't apply the other way. So the EU has not said that the UK has an adequate level of protection. It's not one of those 12 countries. And that is the position. I have to say that is one of the areas where there are sort of talks ongoing, and it may well be we get a bit of joy out of these treaty negotiations between the UK and the EU. But at the moment, the UK is very much a third country, and so you can't move your data from the EU to the UK. In terms of an adequacy decision for the UK, two or three things just to say. I mean, firstly, these things usually take about 18 months. So the EU couldn't start looking at the UK until we actually left the EU. So they didn't start looking at this until the 1st of February of this year. So if we go through those sort of normal channels, there's quite a long way to go until we get an adequacy decision. And the other thing to say is that although this sounds like a very odd thing to say, given that the UK has been part of the EU and until very recently, it's by no means a given that the UK will actually get an adequacy decision. And one of the reasons why it may not get one is because the UK, and the UK is not alone by any means in this, but it's got some fairly sort of onerous mass surveillance laws, which essentially allow UK government to intercept communications and to essentially have a look at people's data. And that's one of the things that might prevent the UK from getting adequacy decision. I have to say, I think, as I say, the UK is not the worst, and it does seem slightly odd that at 10:59 p.m. on the 31st December, the UK is adequate. But at 11 p.m. on 31st December, it's suddenly not, and but that is the way it is, and this is quite a big area. So yeah, in practical terms, again, we end up with this sort of asymmetric situation. You can export your data out of the UK to the EEA, no problem with that. UK says it's fine. If you want to come the other way, so into the UK, as I say, you are a third country. You're in the same position as if you're in the US or Australia or any one of those other countries, and you've got to put in place a safeguard. Now, there are a number of safeguards. The most obvious one, or certainly the quickest and easiest one to put in place, are what's referred to as standard contractual clauses. Standard contractual clauses are essentially contracts which the EU Commission has approved, and what you do is you put one in place between the data exporter and the data importer, and the contract itself sort of guarantees that level of adequacy, that level of data sort of privacy protection, which would otherwise be guaranteed by the data staying in the EU. There are one or two problems with using standard contractual clauses. The first one is they are now getting a bit long in the tooth. They were first brought into existence pre-GDPR, and they are generally sort of a bit clunky, a bit difficult to use. They don't cover all the situations that you might want to cover, so they only cover controller to processor and controller to controller transfers, and they are also generally only sort of bipartite, so they're only sort of one party to one party contracts, which makes them, as I say, makes them a little bit clunky. The other problem with standard contractual clauses is this Schrems 2 case, which you may have heard about. So Schrems 2 was a case all about safeguards for data transfers. It was a CJEU case which was decided back in the summer, and as one of the results of Schrems 2 is that the CJEU have said that standard contractual clauses are valid, so it hasn't struck them out, but you need to be careful how you use them, and essentially you need to assess on a case-by-case basis whether those standard contractual clauses are giving you adequate levels of protection. And that essentially involves looking at the country you're exporting to, looking at the sort of data that you're exporting, how much data there is, and making that sort of assessment, as I say, on a case-by-case basis. And if necessary, putting in place what are described as supplemental safeguards. Now, I'm not going to get into that in any huge detail now. It's a pretty complex area, but there is some very good guidance which has just been adopted by the European Data Protection Board on supplemental safeguards, which sets out a very useful sort of 4 or 5 stage test for doing that sort of case-by-case assessment, and describes what the supplemental safeguards might look like. So that's definitely worth a look if you are thinking about transferring data outside the EEA, including to the UK. So one sort of practical problem here is that it's pretty easy to get your data out of the UK into the EEA. So if you're using a provider in the EEA, but you might find yourself in the slightly awkward situation that you can't get your data back again. So we might find a situation where it's actually very difficult to move your data back to the UK or to access your data once it's in the EEA. So there's a potential problem there. There is a little bit of light at the end of the tunnel on the standard contractual clauses front, and again, this is a fairly recent development, and that is that the EU Commission has just published some brand new draft standard contractual clauses, and they look very good indeed, I have to say. They look far more flexible than the last lot. There are 4 different versions: controller to controller, controller to processor, processor to processor, and processor to controller, so covering all of the bases. And they are very much drafted with the whole sort of Schrems 2 problem in mind. They're not a complete fix to Schrems 2, but the way they drafted certainly points you in the right direction as to what you should be doing to sort of to make sure that you're okay in the light of Schrems 2. As I say, they are draft at the moment, and they're in a sort of consultation period, but fingers crossed they should be coming into law, should be adopted sort of towards the beginning, first quarter of 2021, which would certainly be some welcome good news, and may make this whole area a little bit easier to deal with. At the moment, it's a bit of a headache, if I'm honest with you. So that's data flows. That's pretty big. That's pretty heavy. Slightly, I suppose, slightly lighter, but still quite important, is the whole area of EU representatives. This was something which was brand new when the GDPR came into force, and essentially, what the GDPR says is if you're a sort of non-EEA business, let's say you're a US business, but you're doing business in the EEA in the sense that you're offering goods or services to people in the EEA. Perhaps you're an e-commerce business selling into the EEA, or you're monitoring the behaviours of people in the EEA, then you need to appoint yourself what's referred to as an EU representative. And what that person is, it doesn't have to be a person, could be a company as well. They are really a point of contact for the Data Protection Authority. So if something goes wrong, the Data Protection Authority has someone to talk to, someone on the ground locally to talk to. So the big change there, obviously, is because the UK now has its own UK GDPR. It has mirrored this EU representative provision. So if you're a non-EEA business, 2 things to bear in mind. You may have already appointed your EU representative. You're doing business in the EU. If you've appointed that EU representative in the UK, you need to move that EU representative because the UK is no longer part of the UK. So you need to think about, as a sort of a non-EU business, you need to think about where you're doing business. If you're doing business in the EU, you need to have your UK representative in the right place, and if they were previously in the UK, you need to shift them into the appropriate part of the EU. So that's the first thing. Secondly, if you are a non-UK, non-EEA business, you will need to appoint a UK representative. And in fact, you may need both. So if let's say you're a US business, you're a US e-commerce business, and you are targeting customers in both the EU. So let's say your target markets are France and Germany, but you're also targeting customers in the UK, then you will need a UK representative in the UK, and you will need an EU representative in either France or Germany. So as I say, you may need both. So that's a sort of little technical change which is going to catch a few people out, I would imagine. So if we sort of move into top tips in relation to data privacy, the first 2 or 3 are really around this whole difficult data flow area. It's really important. It's more important now than it ever has been that you map your data flows. You know where your data is going, so you need to understand where you're moving your data, where you're moving your data from, particularly when you're moving it outside of the EEA. So you need to understand what data you're moving and where you're moving it to. and then you need to be putting in place safeguards to ensure that data can be safely moved, taking into account the sort of things that were said in Schrems, hopefully with a bit of help from the new standard contractual clauses next year. You also need to be thinking about representatives, either moving your existing representative or maybe appointing a new representative in the UK. And the fairly obvious thing to say is that once you've appointed your representative, you need to list them out on your privacy notice. And this is the way that people really get caught for non-compliance, because it's dead easy just to look at people's websites, look at their privacy notices, and see whether they've got an EU and now a UK representative. And it's an obvious way for a data protection authority to see whether you're compliant or not without doing very much work at all. So it's really important that you do update your privacy notices to reflect the hard work you've done behind the scenes, and don't get caught out that way. So I think that's probably about enough for me. Apologies, I've slightly gambled through both areas, but they are sort of quite big areas, both of them, and as I say, both areas which have been fairly seriously impacted, or will be seriously impacted by the UK finally leaving the EU as at the 31st December. So I'm more than happy to take a few questions if there are any.
Yeah, we have a question that is for both IP and privacy. What will the authority of the judgments before and after Brexit Day of the EU in the UK?
Yeah, it's a good question actually, and it does come up when it comes to sort of pan-European injunction. So at the moment, if I'm enforcing my EU trademark, I may well be looking for an injunction across the EU, including in the UK. Now, what the UK has said is that insofar as there is a EU judgment, before IP completion day, the UK will honour that judgment. They will give it full effect. So essentially, anything which This is the joys of working at home. I do apologise. anything which happens before IP completion day, will have effect in the UK. Less clear what's going to happen the other way, if I'm honest with you. So insofar as the UK has granted a pan-European injunction pre-IP completion day, not at all clear whether that will be honoured across the EU. Much more clear with stuff coming out of the EU.
Great, thanks. One more question. What should LIA law members advise their clients to do about GDPR?
Well, GDPR is very much here to stay. It stays as it is in the EU. It stays largely as it is in the UK. And certainly to start with, you've got the same system in the UK and the EU. But I think you need to look carefully at what those clients are doing, whether they're operating in the UK, whether they're operating in the EU, and just apply those slightly nuanced rules slightly differently. So it is things like the EU and UK representative that you need to get right. So you really need to look on a sort of client by client basis as to exactly what they're doing in the EU and indeed the UK, and apply the rules appropriately in that way.
Great. I think that sums up our questions. Thank you very much, Nick. Very informative presentation.
No problem at all. Pleasure.
Great. Thank you, everyone, for attending. Take care.
Thanks, guys.
Bye.
Thank you very much.